Hi, welcome to this week's patent series. Today we're going to talk about patent licensing and enforcement, the ins and outs of monetizing your invention. So let's face it, there's no business reason to get a patent if you can't make money from it, correct? So today Matthew is going to discuss how to make money from patents through licensing the technology to others. He's also going to cover patent lawsuits and how they can be used to monetize inventions. So welcome everybody. If you have any questions throughout this presentation, you can definitely put them in the chat. Towards the end, if we have any questions, I will unmute everybody and you can ask them as well. So thank you, Matthew. Welcome.
Thank you, Julie, and I'm glad to be here. As Julie said, I'm going to be talking about patent licensing and enforcement. And, you know, where this comes from, just to start out, is, you know, there's some people who get patents and their only interest in getting a patent is to have some publication that has a name on it. And, you know, there may be, there may be some academics and there may be, you know, some garage inventors who that's all they're interested in. But getting a patent is or can be a fairly expensive proposition. And you don't really want to invest that kind of money in something without having some sort of way to make money from the patent at the end. So I'm going to talk first about patent licensing, and then I'm going to go on to enforcement. And the reason I'm going to do that is it is primarily because the way most companies end up making money on patents is through some sort of licensing. And there may be, and also you should know a little bit about licensing if you're going to have somebody else manufacture your product. This is especially true, you know, if you are actually making a product vis-a-vis, you know, maybe offering a service or something like that that is patented. So let me get started here. Today's topics will be, I'll talk first about assignment, and then licensing, and then enforcement. So assignment, if you're not familiar with the term as it's used in a business sense, basically means sale. It means that you're taking all of your patent rights and you're transferring it to somebody else. Now, there's a kind of license which amounts to a sale, and I'm kind of including that that type of license under this umbrella of a sale. Basically, all the substantive rights of the patent are transferred to somebody else, and that person is known as the assignee. The seller of the patent is the assignor, and the key thing in patents or in an assignment is how much you're going to sell your patent for. It's a really big question because, you know, at a bare minimum, you'd want to recuperate the costs of whatever it cost you to get the patent. But that's not really a profitable proposition, is it? And it's not something that I think most of us would find very appealing, unless we were squeezed into a bankruptcy situation and we had to value the patent asset, and we'd say, well, you know, we at least want to recuperate whatever we put into it, the same way we want to recuperate whatever we put into some inventory or a building that we had invested in. So, you know, I'm going to presume that that's not what we're looking for here. We're looking for something a little bit more or better than simply recuperation of costs. Although that might be your baseline. One way to do this is to calculate a royalty over the course of a patent's term. This is, of course, going to have to be an expected royalty, but you might look at the buyer and say, well, okay, maybe this is a device that goes on automobiles. I'm going to sell this to Toyota America. They sell, they sell so many cars per year. Let's say I don't know, 50 million cars per year. Maybe we'll take worldwide into account. this is a $5 part on which they expect to make about a 25-cent profit. I'll take 10% of that, so 2.5 cents per out of, something like that, and then calculate it over the course of the patent. That's one way to do it. The advantage to that might be, and by the way, the advantage to assignment or sale of the patent is you get out from under it, you don't have to worry about it anymore. You got your money in your pocket, you go out and do something else with your life. Of course, the drawback here is you might grossly underestimate the true value of the patent. You might also grossly overestimate it, but that's unlikely. You'll usually be dealing with somebody who's more sophisticated than you are, has a lot more resources than you do, is much better lawyered than you are. So this is a hard one to get. You can also look at some percentage of anticipated profit. Again, you'll have to do that same kind of calculation. How many are they likely to sell over the 20-year patent term, or whatever's left of the patent term when you sell it? And what percentage of the anticipated profit are you looking at? Maybe 1 to 10%. But it could be higher, it could be lower. It kind of depends on the part, or how much of a part your product plays in the ultimate product. If it's the whole product, then you might look for a higher percentage of the profit. If it's only a small smidgen of the ultimate product, maybe you go a little bit lower. Then there's a possibility of anticipated savings. Let's say we developed a new process for processing a particular product. Let's say it's a milk product or something like that. It's going to be used all over the country at the very least, and it's going to save the users, let's say, each of them $1,000 a year. So you might take all the dairy product producers out there and calculate how much you anticipate their savings or additional profit to be, however you express that. And you might say 10 to 50% of that anticipated savings or additional profit. These can be significant. Let's say if it affects the shelf stability or purity of something, that could be a significant improvement, and you would value your patent accordingly. So that's the simplest thing. You just sell your patent outright. Valuation is difficult. It's and you're going to shoot high. You're going to want to set a high ceiling, and they're going to want to set a low floor, and you're going to negotiate somewhere between those two. The next thing I'm going to cover is licensing. Licensing just means generally that you're going to allow somebody to use your patent as long as they adhere to the terms of the license agreement. You're not going to sue them for patent infringement. You still own the patent, and you're only going to give them certain rights within that patent. So here are some general licensing considerations. Will you also be practicing the patent? There are non-practicing entities out there. You're not required to work your patent under the U.S. patent law. That's not true in all countries, but in the United States, you don't actually have to use the patent. Maybe you have more than one patent, and this is one that's been sitting on the shelf because you don't really use it. Or maybe it's something where you've just found that you can't keep up with demand. And so you're thinking about out-licensing it maybe to somebody who can keep up with the demand, and you'll take a reasonable royalty or some part of their profits from their operations. So will you be practicing the patent? Maybe it's part of a manufacturing agreement. Actually, patent licenses come up a lot in manufacturing agreements. Let's say you won't be manufacturing your own widget or whatever it is. You've got to engage somebody else in that. You can actually as part of that manufacturing agreement, you're going to have to grant them at least a limited license to make it for you. Now, you're going to be careful about this, because if you're not careful, you could actually license them to make it for anybody. And if you don't have a royalty provision in there, you can end up having created a problem for yourself. So, you have to be careful about that. Another question to ask is, if you're not going to be practicing the patent, or even if you are, will the licensee be able to fulfill all demand for the patented product? This is a big one, because, if the licensee is small and isn't able to keep up with demand, you're potentially losing customers, and you're potentially losing sales, and you're not fully monetizing your patent asset. So you want to think about that. Really kick the tires on that licensee and ask, are they really going to be able to keep up with the demand for whatever the product or the process is? Maybe as part of this, you want to grant the licensee a patent or rights under the patent for a limited region. Just like doing a franchise or something like that, where it's pretty standard to say you have a license to sell this particular brand of tools, say in the state of Arizona. You could limit the licensee, theoretically, at least, and this does happen in certain industries, to a particular region. Let's say, the Southwest, and then you state the states that are included in the Southwest. Or if you already got the Southwest covered, you can do the Northeast, something like that. You want to have the flexibility to renegotiate or find another licensee after a period of time. So you can have a license that goes on for, let's say, 5 years. It doesn't extend the whole life of the patent. You just give them 5 years, and then maybe you give them a first right of refusal to renegotiate, or maybe that's just the end of it. You don't give them any right of first refusal or anything like that. And of course, the more you give them, the more you kind of expect in return. So you give them that right of first refusal, you probably ask for a little bit more on the royalty side, because you are constraining yourself. Who's going to be able to enforce this patent? This is a big question. You want to retain those rights for yourself? Generally, they are your rights, and you would be the one to enforce them. But maybe the other side may say, hey, we don't know if we really trust you to make that decision or not. And if somebody comes into the market and starts infringing the patent, we want to be able to have control over that. So a lot of times what will happen is the patentee, the owner of the patent, you, would have the opportunity to file suit against an infringer. But if you don't do that, then essentially the patent licensee would be able to step into your shoes and sue on your behalf. So that's another right. That's another licensing consideration. Does the patent cover a product, a process, or both? Why is that important? Well, they kind of get valued differently. A process is often valued by cost savings or profit enhancement. Maybe the product, the resulting product will be an improvement over an old product, and so you'll get some percentage there. If it's just a straight out product, then the calculus is a little bit different, but it's something you need to think about. Or maybe it's both of them. No, maybe both of those things are included. Does the patent cover platform technology? Sometimes the technology is it's a very general technology. It can be applied to a lot of different things, and it can also be a basis for additional innovation. And we tend to think of those platform patents as being more valuable. They tend to be broader in their application, and so they tend to be a little bit more valuable. And They also lead you to questions like, if they're later patents, are they going to be covered under this license agreement? This may affect the term because those later patents may go longer into the future. And then it may also affect valuation because they may provide additional protection from competition. One of the things that comes up, the word prosecution basically means the right to push things through the patent office. If later patents will be covered, do we want to give the licensee the chance to have a say in how that negotiation with the patent office goes, to get new patents? And a lot of times, not so much when it's an individual or an entrepreneur, maybe a startup company, but on the flip side, if you are licensing from a university, the universities will want to retain the prosecution rights, despite the fact that, and they'll usually grant some sort of comment rights or something like that. But they like to retain control over their intellectual property. But it can be, you can negotiate for more control. It will cost you a little bit more, but it may be worth it. Kind of related to whether it's a platform technology, can it be applied to more one technological field? And I was thinking about this, and I thought, well, what about a new battery? Let's say you had a new battery that had a higher capacity and charged faster, and took up less space, and maybe was cheaper. Okay, let's say we hit all of those things. Well, you can just imagine the areas it might be applicable. We've got the automotive, aeronautics, marine, space, military. All of those might be interested in the battery. You've got smart devices. You've got backups. It could be backups to solar or critical services like hospitals, server farms. I mean, you can just imagine how many different ways this battery technology, if it were really groundbreaking, could be used. Well, you may want to then carve up the fields of use, and we'll talk about that a little bit later. But so that's definitely a consideration. How much of that do you want to give away to somebody? Sell to somebody, and will they be able, just along the lines of something we previously talked about, will they be able to fulfill the demand for those, or do you want to divide that up amongst licensees? So here's some common license terms. Whether it would be royalty or non-royalty bearing. We tend to talk about non-royalty bearing as paid up, right? There has to be some consideration for there to be a license. So what will that be? Will it be an ongoing royalty? Will it be a fully paid up royalty? Or in other words, non-royalty bearing? Will there be some milestones involved in it? Medical devices and pharmaceuticals often have licensing terms where, if certain regulatory milestones are met, the licensee will pay more because they're farther down the line in their development, and they're closer to making a profit on it. Another concern is royalty stacking. This really comes up a lot in the pharmaceuticals and medical device areas, where you might need access to more than one technology in order. Think about your smart devices here. This is a perfect example of a royalty stacking problem. There may be 1,000 patents that cover that. And so when you're calculating the royalty, if you're the manufacturer of that, you don't want to have to pay a huge royalty to everybody, because that will end up eating your profits and maybe just make the device entirely non-profitable. So there may be some royalty stacking provisions in there. Another common licensing term is it exclusive or non-exclusive? In other words, there are different flavors of exclusive, but usually exclusive just means that the licensee gets to practice and nobody else does, and that includes the licensor. So basically, you're telling, it's almost like a sale, but you still own the patent. And as long as they continue to keep up with their terms of their contract, they keep paying their royalties, they keep making progress and coming to market, whatever those terms are, they still have the right to exclude everybody, including you. Now, you can reserve some rights. Let's say you reserve the right to continue to develop the technology. You reserve the right to manufacture a certain number of units under your own brand name, something like that. But generally exclusively means relates to everybody in the world, including the licensor. A non-exclusive license gives you the opportunity to market to more than or to license more than one manufacturer or more than one licensee, and that can be very useful. Let's say you're trying to break up a territory, or break up, say, the United States into territories, things like that. A covenant not to sue. You may not have heard that term, or maybe not as it relates to patents. It basically means that you're agreeing that their use of your technology, which would otherwise infringe this patent, you're not going to sue them for it. So that's basically what a non-exclusive license is. An exclusive license might come along with a little bit more than just a covenant not to sue, but that's basically what a license is. You want to think about what fields of use this technology can be used in. Some veterinary applications, or even even human medical indications can be split up. Let's say you have, I'll just use a real commonplace example, ibuprofen or Advil. It can be used for treating fever. It can be used for treating pain. Maybe, and this is a stretch, but maybe you want to license one licensee to market it for treatment of pain, and another to market it for treatment of fever. Now that seems a little unlikely, and it's a very simple example. But you could have something, maybe a drug that's useful for treating eczema if applied topically, or treating rheumatoid arthritis if it's administered intravenously. So maybe you want to split that up. Maybe you've got two different markets you're looking at there. They don't really overlap, and so you could have theoretically two licensees, and maybe you pick them because one is really big into topical applications, the other one's really big into intravenous, and you want to have the best access to the markets that you can possibly have. So that's where you think about what are the different fields of use you could have for this. Are you going to grant, one way to do this is say the field of use is all uses. Well, that pretty much covers everything. Or you could break it up like I just described. Territory, we've already talked a little bit about territory, but it bears mentioning, if this patent is actually effective in multiple countries, because let's say you've gone through the patent cooperation treaty and you've gotten very similar claims in say Europe and Japan, you could license it only for the United States. You could license it for worldwide, or you could select outside of the United States, OUS, and just say, well, we want to have the United States as our territory. You can have Europe or some part of Europe. You can have Germany and Eastern Bloc countries, but we want to have UK and France, something like that. What kind of efforts are you going to expect from your licensor? You're going to, and these can be terms of use that are industry specific, but they're things like, reasonable, reasonable best, commercially reasonable, et cetera, et cetera. Whether they mean anything depends a lot on the jurisdiction you're in, and so you kind of want to be careful about those. But the point about having something in there about efforts is you don't want your licensee to buy your patent and sit on it. You want them to take some sort of efforts to bring it to market so that you can make a profit. The last thing you want is for your competitor to buy up your patent rights or as a license, and then just sit on it and go sell something else that doesn't infringe. So, that's the kind of thing when you're sizing up your licensee. Well, they might have the ability, but are they going to sell your product and make a profit that you can benefit from? Another thing, enforcement rights is another thing. Who's going to enforce this patent? I talked about it earlier. You as a licensor, you would want to retain those rights, but the licensee may insist on having some residual rights in case you, let's say some derivative rights if you fail to enforce the patent. Termination. How is this arrangement going to end? Is it going to be just a term of years that's perhaps automatically renewed or renewed under certain conditions? Or is it going to be for the life of the patent? Maybe there are multiple patents, the life of the last expiring patent. So, things like that. These are pretty common terms. You need to think about what happens if it's a planned termination or if it's a breach. What happens under a breach? And what provisions of the agreement survive after after a termination for breach? Things like that. What happens in the post-termination period? Are there going to be parts and know-how and things like that returned to you, the licensor? Or are they going to be destroyed, or things like that? What happens to confidential information after this relationship dissolves? Again, are there going to be additional patents that will be added to this license term, and what rights are they going to have to those patents? You should think about that in the beginning. What about associated know-how? They're going to gain a lot of information from you in practicing their patents. What's going to happen to all of that? And do they have a license to use that know-how to make other products, or is it limited to only these products? What happened? I mentioned before. What happens to confidential information? Typically, what will happen is both sides will agree that confidential information is kept confidential unless some outside third party discloses it, so it becomes public through no fault of either one of those parties, or the party that it originates with makes it non-confidential. So it's actually a complicated part of the agreement, and it definitely needs to be dealt with. What are the rights included under the license? We talked about this before, but if it's a manufacturing agreement, maybe the only right you get is the right to make it, and you in that case you would say, make it for the benefit of the licensor, make it for the benefit of me. You could give them the right to make and use. And I should have said under make, you can also include the right to have it made by somebody else. Make or have made is a pretty common way to formulate that. And that means that maybe the manufacturer could have a subcontractor who also makes it. That would count. Selling, importation, and exportation. Let's say it's a product and you need to have it, and they decide to have it manufactured overseas, maybe in a country where you don't own a patent, if you don't give them this importation right, they would, they wouldn't be allowed to do that. And then there's a right to export. Indemnification shows up. I'm not going to go in depth in indemnification. It's a tricky subject. A lot of times, the licensor would ask the licensee to indemnify you against any use of the patent technology that they were found to be to have violated somebody's rights. Maybe let's say there's a products liability suit. Let's say they manufacture ladders using your technology. And ladder manufacturers always get sued. I don't know why, but they do. People stand on the top rung of that ladder and they fall off, and then they sue the ladder manufacturer. Your indemnification clause would be in there to keep you from getting sued as just the patent owner. You didn't do anything. You didn't actually manufacture the ladder. You didn't put it in the stream of commerce. You didn't do any of that stuff. All you did was get a reasonable royalty out of the licensee. But guaranteed, if you don't have that indemnification in there, you will get sued, and you'll be, you may be held partly liable. So you get that in there. The ladder manufacturer says, no, we've got insurance, we'll cover you, not a problem. And there may be a requirement in that indemnification. I should have put a sub-bullet point in there that somebody carry insurance to cover that indemnification. Then there might be limits on liability. And these would be things like, let's say that there was a breach of contract. There might be a limit on the amount that you, the licensor, could recover. Enforcement. So the first thing to know about enforcing a patent is that there is a statute in the law, in the patent law, that highly encourages you to put a patent number on your product, if it can have a number on it. I mean, there's certain situations where that's just not practical, but if possible, if you can put a patent number on an article, then that is notice to the public that this thing is, or maybe, covered by a patent. And that's that's helpful, because notice is an important part of enforcement. And I'm going to talk about letters here. There are different kinds of letters that you can have your lawyer write to enforce your patent. The first one is just a notice letter. Hey, you notice that you're in, I've used notice different. It seems that you're working in our particular field. Did you know we had patents? Here are the patent numbers. And just leave it at that. Basically, that's notice letter. Now you've started a clock running against them. If they continue to infringe after they get that notice letter, they're liable for infringement. And you might ask, well, what happens if I don't send the notice letter? Well, unless you had your product marked, then they don't have notice. And they only had what we call constructive notice back then. They might say, oh, it's too small, whatever. A notice letter puts them on notice. There are also offers for licensing. You might have your lawyer write and say, hey, our client has these patents, and they'd like to offer them to you for licensing. Call us if you are interested. That also works as a notice letter, provided the patent numbers are listed. And again, it starts that clock running. They now are on notice that they're infringing your patent. Then there are cease and desist letters. This is turning up the heat, right? We've been turning up this. The notice is very bland. Licensing is it's a little bit more suggestive. It's like, we kind of think you're infringing or thinking of infringing. we're going to offer you a license. Cease and desist letters are basically, get off my porch. You know, meet them with a shotgun at the door, tell them to get off your porch. Except it's not self-help, but it is. It's a form of self-help, and it's basically saying, we're thinking of, you know, we're weighing our options, and we are, you know, we believe that you're infringing. We have these patents, and we want you to stop. Period. And there may be a threat in there, an implied threat or an explicit threat that you're going to file a lawsuit. And oftentimes, what we do with the cease and desist letters, we actually prepare a draft filing of a draft lawsuit that we attach to the cease and desist letter. You know, we may come straight out and say, we will file on such and such a date. If we don't hear from you by November 1st, we will proceed with filing this lawsuit. So you've really turned up the heat here. Now, the risk with the cease and desist is they might jump your gun in a sense. They might say, we'll just go to court and get the court to declare that we don't infringe. Okay, and maybe they feel very strongly that they don't infringe. Maybe they have an opinion of counsel or something like that, and they may be able to jump the gun and go and file a lawsuit against you, basically saying, we don't infringe, and by the way, we think your patent is invalid. Now, why that's important, I'll talk about in the next slide. We're going to have a lawsuit, right? And where do we file it? Well, we have to file it in U.S. District Court. The only courts that have subject matter jurisdiction on lawsuits involving patents are U.S. District Courts. And don't get to do this in a state court. State court will kick you straight out. They'll read the statute and they'll say, no, we don't have subject matter jurisdiction here. So U.S. District Court, it has to be where the infringer resides, such as the state of incorporation, or where the infringer has a principal place of business. Now, you know, I'm stating this very categorically. There may be some opportunities to file in some other places, but those are the sure dead ringer places that you can file against them. Their state of incorporation or where they have their principal place of business. So let's just say you've sent a cease and desist letter to somebody in Arizona who's incorporated in Delaware. Those are the two places you can sue, Arizona and Delaware. Maybe you thought you might get a better hearing of it in the Eastern District of Texas. A lot of folks have tried that over the years. It used to work pretty well, and the courts have since kind of clamped down on it. It really doesn't have to do with jurisdiction, it has more to do with venue, but so I'm really simplifying the issue here, but these are the, you know, you need to think about where you want to have the lawsuit actually adjudicated. And this is going to depend, this is very strategic, it's very legal in nature. You're going to want a lawyer to make these decisions for you. You're going to need one. You don't want to do these things on your own. What's the point of this lawsuit? Well, there are two ways this could go. Number one, you could get to the end of the lawsuit and you could force the other party to either pay you a royalty or just stop. And, you know, those are, or both. But most patent lawsuits settle. And, you know, when you're settling, and this is a, you know, this is thinking of the lawsuit as a monetization opportunity, right? You sent your cease and desist letter. They've just absolutely refused to pay you a royalty. And now we get into the settlement discussions and everything's on the table now, right? You could sell the patent to them outright. If that's in your interest, you could give them an exclusive license, a non-exclusive license. a covenant not to sue, which is basically just a non-exclusive license, any of those opportunities. But now you've kind of got them over barrel because they went out of this lawsuit. They don't want to take the chance that a jury could come back and tell them, yeah, you're liable for infringement, and by the way, you're doing it willfully, and so you get enhanced damages on top of that. So the lawsuit can very much be a strategic weapon to get to a point where you get a settlement and you get to make money off of your patent. So that is pretty much the end of that of my presentation here. Unless there are any questions, and I will defer to Julie on whether there are any questions or not.
All right, thank you, Matt. That was an awesome presentation as usual. I don't know a lot about patents, but I'm learning over these series. I didn't know if anyone has any questions. I'm going to go ahead and unmute all. So if anybody does have a question, feel free to ask. If you don't have any questions right now, but you think of something later, you can always go ahead and send Matthew an email, or you can contact me and I can give you his contact information. And also, if there is anything that you missed on this webinar and you want to take notes, or you want to go through it again or refer it to somebody who can use this information, it's recorded. It will be posted on the AZ TechCelerator website, on the AZ TechCelerator Facebook page, and also on the City of Surprise Economic Development YouTube channel. So if you have not subscribed to that yet, please do. And thank you. And we look forward to seeing you next week. Same time, same place for our next in our patent series. And thank you.
Thank you, Julie.